Hi all. So good evening and welcome you all back to the business law lesson. And today we are going to discuss about the breach of contracts and the remedies for the breach of contracts. According to the Australian law, we are going to make the discussions today. And here my lesson focus is on the breach of contracts. But before we, basically when it comes to the breach of contracts, we are going to consider about what the breach of contract is, and we're supposed to look at the types of the terminations of contracts, as well as to see the nature of termination for the breach of contracts, in the sense that whatever the contracts which have been breached and terminated. So, and we are going to evaluate on the types of the breaches which are available, and also finally we are going to evaluate on the remedies that we can take under the breach of contracts. So let's move to the lesson, and first we'll get to know about the types of terminations of contracts. Now, what are the types of the terminations of contracts? The ways that you can terminate the contracts. Let's say the first one is termination by performance. Second is termination by agreement. The third one is termination by the term of contract. Fourth one is termination by frustration, and the fifth one is termination by breach. Now anyway, our focus is to look at the termination by breach. Fine. Now, in termination by performance, what do you mean by termination by performance? Now, when there's an agreement, if you can remember, there should be two or more parties, which there's the offeror and there's the offeree, as well as the person who offered the thing and the person who accepted the thing. Right? So when it comes to the termination by the performance, so at the end of the performance, some of the contracts will automatically terminate. So in that case, we say that contract, the termination, or let's say the cessation of that particular contract has been happened just due to the termination by performance, because that is the end of the performance, right? So when it comes to the termination by an agreement, let's say there are some terminologies, or let's say there are some terms and conditions which are included, right? Or even the parties have already been agreed to terminate the contract, right? In that case, let's take an example like termination by an agreement. Let's say an employee is giving his resignation to the company. In that case, he express by giving a resignation letter. The letter of resignation, he signifies, or he express his particular offer on ceasing, or let's say terminating his employment, right? So according to that, the employer will also come into an agreement where by then they will terminate their employment, which means that they terminate their employment contract. In that case, they will terminate their agreement, termination will be happen just because of an agreement. So the third one is termination by the term of contract, right? There are some contracts which include some of the terms related to the termination of the contract. In that case, if someone has exercised that particular term of the particular contract, so that will be concerned as a contract which is terminated by that particular term. So termination by the term of contract is that. Fourth one is termination by the frustration. Now let's suppose there are two parties. One party not actually, that is not a breach sort of thing, but of course again let's say in an event where the one party is no longer be able to do something. As an example, let's say for the employments, right? Even though the company wants to wants the employee to come to the work, but of course because of because of a disease, the employee won't be able to make his attendance, right? So in that case, that will be considered as a termination by frustration, because even though either party wants to work, but still because of another reason the employee is not able to work. So in that case, that will be terminated. Mostly there will be negotiations and things like that, right? But in some case, if the person is not coming to the work, in the sense, that will be automatically terminated or terminated by the frustration, right? So remember that. Now at fifth, we have termination by breach. What do you mean by a breach, right? So in that case, it's like a person, or let's say a party involved with this contract is not performing the contract, right? Let's say we will come into that in depth. I mean, I'll be explaining you that particular part, termination by contract, so termination by breach, right? So let's talk about this one. This is the important part in our discussion, because we are going to discuss about the breach of contracts and the remedies for the breach, right? So we'll get to know. So what do you mean by a breach of a contract? A binding agreement or bargained for exchange is not honored by one or more of the parties to the contract by non-performance or interference with the other party's performance. As an example, let's say you and your employer are having a contract between you both, right? In a case where your employer, though the employer has agreed, if the employer is not paying you the sum, let's call it as the salary, for your performance, in that case the employer has breached the contract, which means the non-performance or interference with the other party's performance. Now that's a non-performance of the salary, as well as it's an interference with the other party's performance, right? Because not getting a salary, in the sense no one will be able to work again and again, right? That is not you're working, you won't work for free of charge, right? So that is one way of breach a contract, right? So okay, fine. So there are some ways where the terminations are happening under the breach of contracts. Now there are breaches of contracts, right? And terminations are happening by the breach of contract. Termination by the breach of contracts. How can you breach a contract? There are ways of breaching the contracts, right? Breach of a contract can happen, breach of a condition, through a breach of a serious intermediate term, or we call that one as a repudiation, right? We will look into that later. Breach of contract can happen through repudiation, and also breach of contract can happen through anticipatory breach. How can you breach a contract through one of these ways, right? It's not ethical though, right? But when it comes to the breach of contract by a condition, we'll first get to know about that. Now if you can remember, when we were discussing about this drafting, or let's say the formation of contracts, we discussed about what the conditions are and what the warranties are, right? The only part that we didn't discuss is the intermediate terms, right? If you can remember, conditions are some of the passages what we have mentioned, or let's say expressed in our contracts, right? Or let's say a condition is a term of contract, the breach of which entitles the innocent party to terminate the contract. Now if you can remember, breach of a condition is just like you do, that will almost it will facilitate you, or let's say if you are the affected party, or if you are the innocent party, let's say by the one party's breach of a condition is known as a plus point for you to terminate the contract, right? Because why? Condition is just a condition, right? And also the bad side of the condition is the breach of the condition. If you can remember, I mentioned this in my previous lessons. If you can, let's say condition, if you breach a condition, then the breach of the condition can be considered as a breach of a warranty, right? So in that case, condition is not just sufficient for terminate the contract, but of course that will also entitle the person who has affected, or the innocent party will entitle to claim over the damages, because breach of a warranty brings you the claim of damages, right? Now see, when it comes to the sort of heavier condition, let's say it's a sort of a severe condition, right? Considering the severity and considering the breach of condition as a warranty, the innocent party can sue for the damages as well. So let's say a termination by a breach of contract, breach of a condition especially, that is very it's very disadvantageable, or let's say it's a loss for the party who breaches the contract, right? Because why? In a case, the other party can sue over the damages as well, right? And also at the same time, anyway, the condition like the contract will be terminated, right, as an effect of breaching of the conditions. But of course, since the condition is considered as a breach of warranty, so in that case the other party can also sue for the damages. Then the third point is most important. Therefore, the warranty claims only on the damages to the innocent party, but the condition facilitates in termination as well as to claim the damages. So be careful whenever you breach a contract. Don't breach the contracts, of course, but whenever mistakenly, let's say if mistakenly happens from you, let's say just because of some sort of another condition, it can be breached, right, from one party. So if you breached any type of a contract, especially the business contracts, through a breach of a condition, it's very severe, right? Okay, fine. Then what's next? Now, term as a condition. What do you mean by a term? Now, previously we mentioned about breach of a condition, right? If you can remember. Then here we consider about term as a condition. Why do we need to consider a term as a condition? Is every term a condition? Yes, of course, because statute said so. The term is a condition since it is said by the statute. Yes, a term which is mentioned in a contract is a condition, but it's not a warranty, of course. If the severity is so high of that particular condition, yes, of course, you can consider a condition as a warranty, where you can same time you can terminate the contract, right, by getting the advantage of breaching the condition, as well as you can sue for the damages. Remember, in determining the term as a condition that occurs, that courts will consider the following. So what are the parts that the courts will consider when it comes to when you consider a term as a condition, right? The way that the term is expressed. So if it is whether it's an implied or expressed term in your contract, right? Is it a term which is implied or expressed? So if it is an expressed, it has a sort of a weightage. In that case, that will be considered as a condition, because it's almost always like it's almost already in your particular contract, right? Then the likelihood consequence of the breach. So if the breach is having a sort of a likelihood to that particular condition, or let's say a particular term, so that can be counted as a condition, right? The importance of the term to the overall contract. Look again. Now, this is what we previously discussed, right? The importance or the severity of the term will be counted or uncounted. Let's say that won't counted as a condition, right? If that doesn't have a sort of a severity on that, if that doesn't give any value to that particular contract, so that will be that will be neglected. But if it has a sort of a severity or a weightage, that will be counted as a condition as well. Whether the damages are likely to provide adequate compensation. Now, in a breach, so you are talking here, what we're talking is the breach by the condition. So if a condition has breached by some party, if it is adequate to provide the compensation to the affected, or let's say in a case plaintiff, or in case we'll say that is the party who is innocent in this case, right? So is it sufficient enough to make any adequate compensation to the affected party? If that term is so sufficient enough, so that will be considered as a condition as well, right? Most of the merchant contracts, they consider about the time stipulation as a condition, right? And also in non-merchant contracts, of course, they can only consider the condition only for the condition considering as a warranty, and only to sue over the damages, right? And also terms related to the quality, because in a sale of good of contracts, we discussed about the saleable quality, merchantable quality, right? Should be usable by the buyer, right? Buyer is always ignorant, so the seller's responsibility or the seller's liable for giving the usable or merchantable quality products to the buyer. So in that case, the related qualities and everything will be known as the warranties, because over the quality any buyer can sue over for their damages, right? If the product is not in a usable way, if the product is not useful, or if the product is not just because of they changed their mind, but of course if that is not usable, so in that case the buyer can sue over the damages from the seller, because the seller has the liability to sell the merchantable quality products and the usable product, right? Fine. Then we'll go to the serious breach of intermediate term. Now we didn't discuss about the intermediate terms in our previous lessons. Now here this is the very first time that we are going to discuss about the intermediate terms. Now if you look at this picture before you go into the explanations, or let's say the descriptive cases, right? You can see the minor impact makes a huge impact over this person, right? This is where it starts and it has come through this way and it gives a huge impact over this. So it is like that. The serious breach of intermediate term. Intermediate terms, of course, that those are not giving such sort of a very what do you call a giant, or let's say it's not a sort of a heavier effect on whatever the terms and conditions, or let's say whatever the weightage on the contract. But of course, an intermediate term can make a sort of an effect over things. We'll see how it happens. An intermediate or innominate, we call it as an intermediate term as well. So an intermediate or innominate term is a term of contract that may give rise to right of termination for breach depending on how serious the consequences are. That is almost, when it comes to the intermediate terms, these are very, these are in middle, right? Those are not actually neglected as whatever, like the implied terms. Whenever it comes to it's not accepted them as the expressed, or let's say very the heavier terms in your, let's say, the conditions in your contracts, but those are very smaller products or smaller phrases known as intermediate terms, right? But the intermediate terms can act in very serious way when the breach has done on an intermediate term in very serious way, right? So the severity of the intermediate term, that all it matters for the termination. If somebody has made a wrong action, wrongful action on an intermediate term, so the termination can be happen, right? We'll move further. Termination by breach of contracts under the termination for repudiation. What do you mean by repudiation? We discussed about this repudiation and renunciation in our previous cases, right? Repudiation means easily it's a refusal by a person to perform the duty, or let's say the obligation, or let's say the liability, or to the another party, right? So when it occurs, the one party is actually rejecting or refusing some of the duties that are being asked to do in that particular contract to the other party. So in repudiation, if one party does not act in a way where to comply the contractual obligations in the contract, so the innocent party can terminate that, providing the grounds of the repudiation, which has already been repudiated by the other party, right? So if a person is refused or repudiate to do something, that comes under the termination for repudiation, right? Termination by the repudiation, right? Then termination for anticipatory breach. Now these things are happening in today's world, because anticipatory breach is not considered as a civil wrong, or it's not a direct breach, right? Anticipatory breach is something that you have almost like the party who is going to breach the contract is almost like inform the other party of the breach, right? The reason is in some sort of innocent situation, or let's say in sympathetic grounds, these things can be happen, right? I will show you how. An anticipatory breach occurs when a party demonstrates its intention to break a contract through one party indicates, right? This is how they indicate, right? Through one party indicates the other party before the time for performing the contract is due that they will not be able to perform their side of the contract. As an example, during this coronavirus season, you may have heard of most of the people are having financial issues, the financial difficulties, and also some of the people, those who have owned the buildings under the rental agreements, the rent contracts, they are having problems in paying out the rents, right? In that case, without, now as an example, let's say in an event where the lessor will not receive, or let's say lessee is not actually paying the sum which is due for that particular month, or let's say the rent income of the lessor, that will be considered as a breach of contract, right? Actually, if that is not informed by the lessee to the lessor, that will be counted as a breach of condition, and the lessor is having the power to terminate the contract by the breach of condition, right? But of course, when it comes to the lessee's side, or let's say the lessee's end, if lessee is always like, let's say the lessee has already expressed his inability to pay over the particular rent to the lessor, so then the both are in the agreement of anyway the lessor knows that the lessee is not in a position to pay over the liability, as well as lessee has earlier informed the lessor about this inability to pay over the liability, so that that particular condition can be taken as an anticipatory breach, though it's a breach by the law of contract, or let's say according to the agreement or according to the contract that they have signed. So that is basically an anticipatory breach. But of course, since that is a breach, right? But of course, since they have communicated through, then it's considered as an anticipatory breach, right? However, vocal or written confirmation is not required, and failure to perform any obligation in a timely manner can result in a breach. Now suppose this is not regarding the anticipatory breach. Now to happen a breach, right, to make it a breach, it's enough that if the person or the party is not communicated in vocal manner or in writing manner, right, it's not required the confirmation of the confirmation of the breach in vocal or written. But of course, failure to comply or failure to perform any obligation in a timely manner, or let's consider this, or let's call it as the sufficient time, right? So that can be result in breach. But if the parties have already been communicated about this breach which is going to happen in the future, right, so that will be considered as an anticipatory breach. But anyway, since it's a breach, the affected party, or let's say basically the plaintiff, can either terminate the contract, or else if he wants, he can continue the contract. In our case, let's say lessee was not in a position to pay over the liability. By giving an exclusion, or let's say by giving an excuse to the lessee, the lessor can still held his whatever the contract with the lessee by facilitating him to continue his tenancyship, right? Fine. Then we'll move. Now, what are the remedies that we can take in connection with the breach of the contracts? There are 7 main remedies that we can make, right? The first one is recovery of the contract price. You can recover the price, right? That the contract price. And also the affected, or let's say the innocent party, can ask for the sue for the damages, right? They can sue the affected party, or let's say the plaintiff, or even the innocent party can expect some specific performance from the person who breached. And also the court allows some sort of injunctions. Also the rectifications in some matters, we can see in general life, some of the rectifications, or let's say the mismatchments in agreements are being made or are being corrected by the court of law, right? Rectifications. Restitutions are also like that. And also rescission, right? These are not recession, these are known as rescission, right? These are the let's say these are the remedies that are that can be made under the breach of the contracts, right? We'll get to know about them, right? So recoveries of contract price. Now remember, you can only recover the contract price. What do you mean by this? Take the example, the innocent party. Basically we call him as a plaintiff because the innocent party is the person to only make the complaint again, and also in this instance we'll count him as the unpaid seller. Now when it comes, that's because there's a relevance, right? We discussed about the unpaid seller scenarios in our business law lessons, so because of that we are getting that unpaid seller, the person or a seller who didn't receive his money or even received a sort of bill of exchange, let's call it as a check payment, under a sort of a condition. So it has to be an unconditional payment if you want to make him an unpaid the paid seller, right? Otherwise, if he got a even if he got a sort of a bill of exchange, but if it is under a condition, so he will be a person who received a bill of exchange under a conditional payment, right? So he's an unpaid seller. Now the unpaid seller, though the innocent party, can recover the price of the contract as a result of breach of the contract by the other party. Now suppose the person has not paid the bill. Let's say even though he has transferred the title, even though he has delivered the commodity to the doorstep of the buyer didn't make the payment on time. In that case, he doesn't have actually a lien to execute because the goods are already being delivered to the doorstep of the buyer. So he doesn't have any lien to execute, and he cannot ask the the cargo to bring them back, right? Because it's almost delivered, right? It's not a sort of a executory thing, right? It's already been executed. So because of that, the only remedy that a seller can make is sue for the price, right? We discussed about suit for the price, right? So the contractor, or let's say the innocent party or the unpaid seller, can ask to the price from the buyer, right? So in Australian law, or in Australian commercial law, the Sales of Goods Act in 1958, section 55 states that where the property in goods has passed, property in the sense that is a title or the ownership of the goods, in goods has passed from the seller to the buyer and the buyer has failed to pay, see the breach, right? Buyer has failed to pay the contract price, the seller may take an action to recover the price. So the seller is having an option to recover the price since the property has already been transferred to the buyer. If the property has not transferred to the buyer, even though that has already been let's say delivered, so the seller cannot take any actions against the buyer, right? But if the property has transferred, even the stock is held with the seller, but seller can sue for the price. That is actually, he can make the actions to recover the price, right? Fine. Then what? Damages. We discussed about the damages as well. Now when it comes to the anticipatory breach, I told you about the communication which is happening between the two parties. Those are coming to an agreement. But when it comes to the anticipatory breach, of course we can exempt these damages, because the damages is not sufficient, because they have the mutual agreement between them about the breach which is happening in the contract. But except for the anticipatory breach, the innocent party can sue over the damages. Now basically the damages happening if you have considered the condition as a breach of warranty, or let's say a breach of warranty will lead us to claim over the damages from the other party, right? C. Can sue over the damages under the grounds of breach of warranty or considering the breach of condition as a breach of warranty, right? There are two circumstances. Then the breach does not have to be the only cause, but it must be sufficiently important that but for the breach the loss would not have occurred, right? It should not be the main root cause, as I told you in my previous lessons. It has to be sufficient enough. If the breach is sufficient enough, then the other party can sue over the damages, right? And in some cases there are agreed damages. Now in some cases we can see especially whatever the contracts which are associated with the risks, right? Whatever the contract which are associated with the risks, we can see the either party are agreeing to whenever they are performing the agreement, right? Whenever they are signing the agreement, even they agree to a minimum, or let's say a maximum or a ceiling of damage price, where in an event which one party is not in a position to perform the contract, so they will agree to a maximum extent of a claim from the other. So that is called damage, right? So whenever the parties have already been agreed for the damages, which at the moment which they are agreed, the parties are agreed to an amount of damage at the instance of breach, right? So those are considered as the agreements for the damages, right? Okay. It is the plaintiff's duty to mitigate the losses. Now, whenever the losses are happening, that is the plaintiff, or let's say the affected party's duty to mitigate the loss, right? How can you mitigate? How can you mitigate? The reason is, if you are allowing, or let's say if somebody allows you to maximize, it has to be mitigate. I mean, the person who has affected, the loss has to be mitigated through whatever the compensations, right? So we'll discuss about later. And also, damages should not be too remote from the breach. Now, to claim over a damage, the reason that you express, or let's say the condition which he has already been breached, has to be a very relevant impact over the damage which is happening, right? So damages should not be too remote from the breach, right? Now, as an example, I think mostly you don't have, you can't understand this well, so that is why I'm getting this example. Damages should not be too remote from the breach, right? As an example, let's say somebody has knocked his car on your let's say the wall, right? Let's say it is your covering wall. So one has knocked on your wall. You cannot ask the damages to pay over the damages which has happened to the house, right? Because that is only your brick wall, right? That is your outer fence, right? If somebody has knocked a car on your let's say, it's like that, right? If a person has made a wrong decision, and let's say something has affected on your business in a one part, let's say one cluster, you can't ask them to pay over the whatever the losses that you bear in your business in full, asking the damages, right? So damages should not be remote from the breach. That has to be relevant with the breach, right? Okay, we'll move further. So damages continued. Here, damages are calculated to put the plaintiff in a position he or she would have been in if the contract has been properly performed, right? It's like basically give a neutral effect to the plaintiff which has affected, let's say the party who has been affected with this scenario, to give him a normalized position, to cure the position. That is the idea of paying, or let's say allowing the let's say the affected party to claim over the damages, right? And also damages can claimed as expectation losses, personal injuries, disappointment, distress, or discomfort. So under these three scenarios you can call over the damages, right? In an event of a contributory negligence. Okay, what do you mean by contributory negligence? Whenever we are discussing about the negligences, we just touched on the contributory negligence. What do you mean by that? Contributory in the sense the either party has contributed. Let's say even though the plaintiff is innocent in the grounds, but of course in first circumstance where the other party breached the contract, if that is having the influence by the innocent party by the act which has he performed in previous case, or let's say the innocent party's act has been influenced the other party to breach the contract, so those are known as the contributory negligence. In that case, the court will involve and make some adjustments over the some of the damages which are to be claimed by the affected party, and they will make some reductions on the amounts of damages as to maintain the equity or known as justice. Because if it was happened due to an influential matter, so the damage has to be mitigated, or let's say it has to be reduced, because it has happened due to an act by the let's say due to a contributory negligence of the party known as the plaintiff, right? So because of that, the court will make any reductions from them, right? We'll move further. So what are the other remedies? As I told you, there are 7 or 8 remedies, right? So 7 remedies basically. So the next one is specific performances, right? So you can sue over the price, or you can ask for the recover the price, or even you can go for the damages, or even you can go for the specific performance. So let's say to do a specific performance, it is the responsibility or the duty of the courts to ask a party, mostly the defendant, to make a contractual obligation for a specific performance, right? In civil cases, we can say some of especially in the cases of divorces, we can see some of the people will ask, the courts will ask from some of the people to perform a minimum, let's call it as a sum to be paid within a month, right? So that is basically a specific performance, right? That is actually paying a compensation, of course, but when it comes to that, it has to be done in a regular basis, which means that it's a specific performance, right? As a breach of whatever the legal consequence, right? And then the injunctions. What do you mean by injunction? It's an order requiring someone to stop doing something. It's basically a refraining, right? It's basically a restriction. Injunction is a sort of like restriction by the court of law. And also the rectification. What do you mean by rectification, right? In some cases, especially in some circumstances, the parties are being misled, or let's say in some cases they have been mistakenly written down some of the contracts in the rectification, the unrectified contracts. In that case, it's government, or let's say it's the responsibility of the courts to rectify them and give them the order of the court, right? And then the next one is, don't miss up with these two concepts known as rectification is one thing, and the other one is the restitution. What do you mean by restitution? It's way like when a court orders restitution, it orders the defendant to give up his or her gains to claimant. Now let's say in an event where you have made a sort of let's say it's actually a crime where let's say by using some of making the other party vulnerable, you make some sort of a profit, or let's say you make some profits at the cost of the another party. So those cases has to be resolved through the restitution, where the other, let's say you will ask the defendant, right? The person who did that sort of illegal thing will ask to pay whatever the profits that you gain through that illegal, or let's say that vulnerable thing, right, to the other party, the party who has been already affected, right? So in that case, the government or the court of law allows the other party or the plaintiff basically to reclaim the money or the gains that you got through that particular incident, right? As well as to claim a reasonable amount from the defendant, right? So these are the things we can see as the other remedies in connection with the breach of the contracts. And also rescission is another act, right? This is the final thing, right? Rescission. So what do you mean by a rescission? Act of bringing a contract to an end whereby the parties are restored to the position they occupied immediately prior to the contract. Now let's suppose two people have opened up a business of let's say employing let's say deploying 500,000 rupees by them, right, equally. So which means that altogether like 500,000, so each will get 250,000 rupees, right? So they deployed 250,000 rupees each as the capital and then started a business, and finally it's found that the let's call them as party A and party B. So both were deploying their funds, and it's finally found that A has fraudulently acted and earned 750,000 rupees out of this 500,000. So because of that, he has to pay the amount that he gained fraudulently through the business activity to the other party, right? That is under the previous option what we discussed as restitution, right? And then the contract will be terminated by the court of law, right, by dissolving all its liabilities and paying them a sum of 250,000 each, right, and making them in a situation where they were even before they started this particular contract, or let's say the parties are restored to the positions that they have occupied immediately prior to the contract, right? So contracts may be resigned, right? These are rescinded for in the cases of misrepresentation, right, whatever we discussed during last week, duress, undue influence, mistakes, and unconscionable conducts, right? So we discussed about the unconscionable conducts under the vitiation factors, right? So unconscionable conduct is one way of doing some sort of it's not a negligence, it's a crime, right? You use some of the disability of a person or inability of a person to gain over a profit or something like that, right? You will create a benefit for you by using the other ones, putting other ones to the vulnerable condition, or else putting the other ones disability. So that is what you call as unconscionable conduct, right? And also rescission is not a termination, but it's a wipe out of a contract. So basically it's not a termination, but it's a basically zero, or it's a wipe out of a contract where we consider the contract was not existed before, right? So these are the things that I wanted to discuss today. So thank you very much. Hope you enjoyed the session. If you do have any concerns, please let me know via my email. Thank you.